Hello, 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 and welcome to another edition of the Consigliaries. I hope I say that right. Consigliere, whatever. Show on the College Football Mafia Network. I'm your host, Nathan Bomber Brown. And with me are two of my good friends. It's becoming a close knit family of all these legal and very smart writer people that are tracking the house settlement and everything that has to do with the business of college sports. So I want to invite you first. Make sure you subscribe to this channel if you're watching this. Turn on your notifications so you know when our tweets and our shows will pop up. Leave us a comment or question. Give us a thumbs up and let us know how we're doing. Obviously, follow us on Twitter. And Joe, if you want to, on the picture down below, there's three dots. You can click on that and you can add a tag underneath your name if you wanted to put in your Twitter name, or you could just add it to your name too if you want to put your Twitter address there. It doesn't matter to me.
Oh, there you go.
Yeah. But I want to thank everybody for being here tonight. This was a show I wanted to do a couple weeks ago. Everybody knows I got sick. This week, it's all about just waiting pensively for this catch up on House and everything that Judge Wilkins is going to do. It's Wilkin. Will do, and we're going to talk a little bit about that tonight. So I invite everybody to sit down, pull out a cool one, as it were, and listen, because these are the smartest guys that are on YouTube right this second, and I guarantee you will learn something as we talk about this house settlement and everything that's associated to it. So first of all, Joe, why don't you introduce yourself and tell everybody what you like to do and why you're here?
Hey, how's it going? I appreciate you having me on. So I'm a professor of sport management at Southeastern Louisiana University here in Hammond. I say here, I'm in Baton Rouge. We're done for the semester, so I'm at home doing this from my home office / nursery here. So I do most of my research on legal issues in college sport, and obviously the biggest one has been NIL, and obviously the biggest part of that is now this big house settlement and litigation here. And then, relatively about a year ago, I guess I started writing for Forbes Sports Money. So usually 1 to 2 articles a month. And right around the hearing, I cranked out quite a few trying to explain the hearing as best I could in layman's terms, as everyone, fans and even administrators are trying to navigate exactly what's going on here. So,
It's been a challenge, hasn't it?
yeah, well, there's a reason you have a group of like 10 lawyers on Twitter. And,
It's
normally
true.
you get a group of 10 lawyers together, you expect blood to be shed. But the problem is we all pretty much just agree on most of this.
At
So
this point,
that's, yeah.
yeah, it's the circular shotgun, right? If whoever gets shot first is going to take everybody else down with them. That consigliere group, by the way, I'm selling access. So if you'd like access to that Twitter group, send me $100 and I'll invite you in. Other than that, not many people get in that group, and so I appreciate both of you guys being part of it. Ryan, of course, we've had you before too, both Joe and Ryan. You want to introduce yourself and refresh everybody and tell everybody why you're here?
Sure, and thank you for having me back. I appreciate it, and I very much appreciate, as I mentioned before, the Conciliere name. Obviously, from North Jersey, we know a thing or two about that. There
Yes,
is no
for
such
sure.
thing, by the way, as the mafia. So I'm a practicing lawyer here in northern New Jersey and in New York. I'm admitted to practice in both places. I practice in federal and state court in New Jersey and in New York. I went to Seton Hall University School of Law many years ago, graduated in 2002 from our great Big East institution. And I had the opportunity and privilege to clerk for a United States District Judge here in the District of New Jersey, Dennis M. Kavanaugh. And from there, I worked at a law firm that was headquartered here in New Jersey and had offices throughout the country. I left there and came to Stevens and Lee, where I've been since February of 2021. And throughout my legal career, I've been able to touch on a variety of things, mostly litigation based, federal and state court. But in around 2016, I had the opportunity to become certified by the NBA and by FIBA to represent NBA, G League, NBA, and overseas basketball players, which has obviously transitioned to now representing college athletes in this ever-changing NIL space.
Right. Absolutely, and it's changed, hasn't it? What NIL was, let's just start there, and both of you guys can talk on this. We'll just have a conversation.
Sure.
What NIL was 3 or 4 years ago to where we are now. I don't care which one of you wants to take that, but that progression has just been fascinating to watch as an outsider, certainly not somebody who's a legal professional.
Well, I'll go ahead with this one a little bit, Ryan. I
Yeah.
think it's important when you talk to non-lawyers about this is that NIL rights are something that every person has. You have the right to monetize, your own name, image, and likeness. That's just something that we've stripped away from college athletes prior to 2021. And I mean, like if Wheaties wanted to put me on their box, I don't know why they would, but if they did, I could sell that right, or I could grant them permission to do it for free.
Right.
But I have the rights to do it. They can't do it without my permission. And so we took those rights away from athletes for decades. And so a lot of people talk about like how we bestowed some special right upon them all of a sudden. It's like, no, we just stopped, taking away their rights that we had done for a long time. And the NCAA, let's not forget, it's like deja vu, by the way. It's feeling very 2021-ish right now. They didn't do this willingly. They got dragged kicking and screaming into the NIL era. And they really missed an opportunity to maybe have some control over it by just dragging themselves all the way till they lost, until the Alston ruling, which wasn't directly NIL, but you got smacked down 9-0 by the Supreme Court. Like I said, you can get that many lawyers to agree on anything, it's not good.
Right.
And not, I mean, obviously the Kavanaugh concurrence, which, it's not law, but everyone likes to quote it. The NCAA is not above the law. And so that's kind of what's gotten us here, this full circle moment. It's really not just NIL. The NCAA has done this. If I were going to write a book about the NCAA's legal strategy, I'd probably just call it Kicking and Screaming.
Right.
And this is what they do and they lose all their leverage when they do this. And they've done it again. And I know I probably rambled a little bit too much there and went from what NIL was to what it should be.
No, it's good. People need to understand it was a natural progression. It wasn't one day this, the next day that.
But then, I think, I wrote about NIL with Alicia Jessup before it all became legalized and really focusing on the potential Title IX ramifications. And we all knew that boosters would kind of do some shady stuff. It's college sports. That's what boosters do, right? I don't think anyone prior to them being formed actually fathomed a collective. And we probably should have. It seemed like the obvious thing, but you can go back and look at all the scholarship, all the articles before that. No one talked about this. And the problems with the collective, if you want to call it a problem, is that this wasn't NIL. NIL is supposed to be use of your license or use of your name, image, and likeness for a business purpose, to market a product, to put into a video game, and what have you. And while we do have some legitimate NIL, it seems, a lot of the women's basketball players do really well during the tournament. What those collectives do, their business purpose was putting money in the pockets of athletes at a certain school. So what we've got here now, and the NCAA had opportunities to try to put guardrails around this, and they kicked the can for, I don't remember.
They've done that for decades around different things, haven't they? They can't seem to get in front of anything.
Well, California, when they passed the Fair Pay to Play Act, which was really an NIL bill, they gave you like 4 years of lead time, at least to start with. They passed it in 2019. They said it didn't go into effect until 2023.
Oh, geez.
And the NCAA did nothing. And then, Florida and Texas and a couple others jumped in, said, hold my beer, there's going in 2021. But that's still, they had almost 2 years to do anything. And their interim NIL policy, which as far as I know is about what they have in place, it could have been written on the back of a cocktail napkin. and this is an organization that loves its rules. It's got a 465-page manual to talk about what athletes can and can't do, and all they could come up with for their bugaboo, the biggest threat to their mere existence that they fought tooth and nail over was a couple of, nonsense bullet points, in all honesty. And they're kind of doing it again with pay for play. And so this is what it's turned into. Again, the collectives, that's pay for play. It's not legitimate NIL. Those collectives don't have, I won't say all of them. I know there's a couple that have created like special content, and you subscribe to the collective and they pay the athletes with that money, but they're actually.
BYU has one. It's called Coug Connect, and it does that exactly. They go out to like dinner socials, or they'll go to a restaurant and sign autographs. That's how they've chosen to handle it.
Yeah, well, those have the most staying power. That's legitimate business. Now, are they doing it mostly because they want to put money in athletes'
Of
pockets?
course.
Yeah,
Yes. Yeah.
but
It's not
there's deliverables there. They're creating something. There's some overhead,
right.
and there you go. That's a business. It is what it is. But I mean, the rest of these collectives, especially the ones that we're trying to operate as nonprofits, and that's pay for play, and we all knew it. I mean, then I'm going to butcher his last name. I have no idea how to pronounce it. I've read it 500 times. But the Tennessee quarterback, Nico.
I am me of I'm a Leva, something like that.
Yeah, I'm a Leva. That's
I'm
what I
a
went to, and I was like, "That's too good. That can't be what his actual
I
name
am
is."
a I am a Maliva,
I
something
am
like
a
Yeah,
liaison.
I am a Maliva. There we go. All
and
right.
he didn't even fulfill the dummy,
No.
deliverables they had in the Tennessee contract, at least according to
That's brutal.
reports. And
Yeah.
they didn't put those there because they cared about them. They put them there so they could make it look like an NIL contract. And
So,
here we are.
Ryan, what do you think about that? That idea that where it started, where we've gotten to, you actually deal with player contracts,
I
or at
do.
least some. And I think where the rubber meets the road is that transition from what Joe is saying to actually putting in an application, right?
Yeah, and I'll follow what Joe said. Look, at the end of the day, there need to be actual deliverables in these contracts, and those deliverables absolutely must be performed. Otherwise, it is just that. It's just a no-show job, and you're getting paid.
Right.
I think at the outset, um, NIL was supposed to be, what Joe mentioned, your third-party brand deals. I'm a women's basketball player, and I'm sponsored by, whatever, Lululemon or Viore or something. Take Olivia Dunn, for example, right? That's the type of stuff, or Paige Beckers. That's the type of stuff that I think NIL was the intended purpose of NIL. It quickly morphed into this NIL collective world where you had a group of alumni who would get together for the singular purpose of raising funds to pay for athletes to attract them to go to the university. I mean, it is what it is, and we're all calling it NIL, but look, this whole thing is pay for play, no matter how we look at it. There's no look. I always used to say before NIL. When I used to complain about all the coaches' contracts making millions and the players making nothing, and the players being the ones that earned the coach those contracts. Look, I would always say the athletes are the ones who are going to see play. The athletes are the ones who are earning the compensation for the
Right.
for the NCAA, for the conferences, for the coaches, for the universities. And they should reap the benefits of at least some of it. Now, we've kind of morphed into this NIL collective space where guys are just funneling money to players. You need to have deliverables in these contracts, as I mentioned before. You need to actually perform the services. It can't just be a no-show job and suddenly you got $500,000 in your pocket just for going to school. And look, we'll touch on the clearinghouse issue and Deloitte
Right.
and all this other stuff. But at the end of the day, whatever a collective or a third party or a revenue share from a school, whatever they want to pay somebody, they'll pay somebody, right? At the end of the day, if you've got football and basketball obviously being the revenue generators, arguably, but if you have a Caitlin Clark and you have an Angel Reese or a Paige Beckers, you're going to unload a ton of money to get them to go to the school. It is what it is, right? So I mean, we could have a broader discussion on what college sports has really turned into. Well, arguably turned into. I think Joe and I may be on the same page where it's kind of always been a professional sport. Just we call them amateurs, right?
Well, from a fan's perspective, it obviously was. I mean,
Sure.
I'm a fan of a couple teams across the nation, and every one of those situations, I'm a fan first. I could care less about the economic second. So just give me a
Yeah.
team that'll go out and compete.
So who are your teams? Who are you rooting for?
Well, BYU first of all,
Yep.
and
You
then
don't
I'm
say.
Pacific Northwest. So what'd you say, Joe? I'm sorry.
Oh, I was like, you said BYU. I'm like, yeah, you don't say. You just completely decked out over there. Yeah.
Yeah, right. Yeah, sorry. It's excuses. University of Washington. I'm from Washington State, so I grew up in the Palouse with Washington State and Washington. So those are teams that one was in or one was out and the other two were always in a conference. So back in the day, 10 years ago, the big cry was access,
Right.
right? People, it was about access. It wasn't about money. It wasn't about paying players. And it's funny that I think it was Joe that mentioned the whole reason NIL jumped out to the public spheres because everybody was looking forward to NCAA 25 and paying the players to
Sure.
have their names. Everybody remembers the old
Yeah.
Tecmo Bowl, no names, and it was all numbers, and so that's everybody's playing Alabama, right? There were no names on any jerseys, and so that's where I think the public consciousness has looked at it from the outside. Now you're talking big money contracts. You're talking. Let me do a quick reset too. I'm going to leave you there. Just sit on that for 1 second.
Sure.
We're going to be turning off X. This is the first time I'm doing this, at least. We're going to be moving everything over to YouTube. So I encourage everybody to make sure if you're on Twitter, follow all of us on Twitter right now. Make sure you know where to find us in future. Turn on those notifications. And then I invite everybody to jump over on YouTube onto the College Football Mafia Network. And we're live right now. And you can watch the rest of this show. This is going to go as long as these guys want to go tonight. That might be 5 minutes. It might be 2 hours. I don't know. But the rest of the show will be over on YouTube. And I just want to invite you guys to jump over there. Okay, Ryan, I interrupted you. I'm sorry.
No, well, look, I was going to say you're a fan of BYU, not because they have a great science department, right? I mean,
No.
you're not, no offense to the science department, but you're not
Right.
buying tickets for college football or college basketball or whatever it is you go and support
That's right.
for any other reason than watching the athletes,
Yes.
right? I mean, I go to Seton Hall games. I have season tickets to both men and women's basketball at Seton Hall. As much as I love the coaching staff, and I'm very close with both of them, I'm going to watch the players. My fiance, and she's watching. Hello, honey. I'll be home soon. We have season tickets to UConn women's basketball. So we'll take a drive up to Connecticut, which is, 2.5 hours to go to the XL Center and watch UConn play. I mean, we
Right.
had the opportunity to watch Paige Beckers. I mean, that's phenomenal. We're not doing that because UConn has a great, science lab. At the end of the day, and look, I'm not going to hide it. I'm pro athlete, largely 100%. I've had the opportunity to represent professional basketball players, and that's now transitioned to college. I represent college players. I also represent a couple of collectives, but by and large, it's college athletes. One of whom was told, by the way, by the coaching staff at BYU football, your roster spot is being eliminated.
Yeah, that sucks.
So, I think, look, we talked about Tecmo Bowl, we talked about EA Sports, right? I mean,
Yeah, right.
They're using the intellectual property of players, and whether the image of a player is on a paper ticket, which we don't use anymore, but whatever. You've got their images on EA Sports.
All the jersey sales that are in the pro shop, right? I mean,
but
it's ridiculous.
Look, any fan, if I'm an athlete, right, and EA Sports says we're going to use your name and image and likeness, and we're going to inject it into this football game that's going to be played by millions of people across the country, if not the world, and you're going to pay me $600?
Yeah.
I mean, here's Deloitte out here supposed to be, right, this forthcoming clearinghouse on what fair market value is. I mean, that alone is not fair market value. And
isn't that a joke? It's an oxymoron, isn't it?
Yeah. Well, like I say that because, and I don't want to get on a soapbox, but it is high time that the players earn the compensation that they deserve and have deserved. We can talk about the settlement and whether that's the appropriate avenue by which to do it, but I think not. I saw Joe shake his head no. I mean, it's a complete disaster, but we can talk about that too.
Go ahead, Joe.
Well, no, I think he's right. The settlement, I think that's probably what everybody wants to talk about now. We've kind of gotten here. It's, like you said, it's just bad. And I know we've been very focused on the roster limits. And to me, that is the worst part for a multitude of reasons. And I think we'll probably spend a lot of time talking about that. But before we even get there, let's not forget, and we've all kind of given up on it because it seems like that's all Judge Wilkin was interested in was the roster limits anymore.
Right.
But capping revenue share at $20.5 million. Now, look, is that better than the zero that the schools are technically allowed to pay the schools now? Sure. But, I mean, antitrust doesn't allow you to put a cap just because you put a higher cap. It wouldn't even matter if this were $1 billion. It's still a cap. Now, granted, at that point, It's effectively not. No one's going to pay $1 billion, right? But $20.5 million is still a cap, and it's a restricted one. I mean, the belief is speculated. Now, you never know. There's no reporting agency, although Deloitte's trying to fix that for all these NIL deals. But the Ohio State football roster allegedly costs $22 million by itself. And now we've got to allocate $20.5 million across multiple sports. And I don't think that the SEC and the Big Ten, I know this is mostly a Big 12 show, but those are kind of the outliers. I don't think they're going to like the result of some of this, to be candid, because if you're a Big East school, you still have pretty good money. You don't have Big Ten or SEC money, but you also don't have a football program to pay for.
Yep.
And I think if this goes into effect, you're going to see a lot of money get funneled into Big East basketball that the other schools, if they're playing by the rules, simply can't afford to do because they said they're going to put 75% of their money into football and maybe 15% into basketball, and everyone else can fight over the 10%. And so the small schools might start to get strategic. It's like, cool, well, we can't compete in football. We just can't. But if we're willing to put as much money as we can into baseball and they don't have any money left over for baseball because they're spending it on softball or what have you, they may push it. So this is not fair market value because they're already trying to front load deals so they can get in before the cap goes in.
Well, isn't fair market value is stupid anyway? That's a red herring because what's fair in San Francisco is not what's fair in Provo, Utah.
Oh, yeah, that's actually a very valid point, right?
It's what the hell are they even thinking? Trying to compare across markets? What supercomputer are they going to put in front of this that can do the appropriate quantifications for living expenses and how much food costs and all these other things? In my opinion, the clearinghouse, while is a great ideal, I see no way that they can get that implemented the way that they intended it.
Yeah, and I kind of convoluted issues there. A cap into the clearinghouse that's supposed to, talk about third-party deals, right? Because any money the school shares under that
that's
cap,
only third parties. Yeah, that's
that.
right. Yeah. That's right. Yeah.
But so just I'll hammer home the point on that salary cap. It's still a cap, and it's still against antitrust law, which blew my mind. That didn't get more. I'm not an antitrust expert. I talked to some. Ryan, maybe you know more about this than me, but how we can improve a settlement for an antitrust claim that continues to violate antitrust law facially. It's a restriction of trade by a monopolist. I don't understand how it's not an antitrust violation, and we're allowing it in the settlement. Pretty mind-boggling. The clearinghouse part of what we want to talk about tonight is just inviting a mess. None of these third parties, whether they be for legitimate business purposes or whether it be a booster who owns a car dealership and wants to promise Jaden Rashada $20 million and not give it to him, hypothetically, of course, right? They don't want to disclose their deals. They probably, and Ryan, you may be able to speak to this, a lot of them probably have NDAs attached to them. Like,
oh, sure.
These are private contracts. And now the NCAA and the Power Four, I guess, or whoever is going to enforce all this is saying you have to report your deals over $600. And then we're going to see if we think this person is an associated entity. And if so, we're going to run it through fair market value analysis. And if we find out that we don't think it's fair market value, well, someone over there is going to sanction you.
Exactly.
This is tortious interference with the contract. That's one of those you don't really talk about that much in law school because you have to be really stupid to do it. And again, here we are. We're not even like doing it quietly. They're doing it very publicly. And then there's the cost of it. It's somewhere between $5,000 and $500,000.
Right.
It's like the cable guy. I'll be there sometime between 8 a.m. and 4 p.m. A Thursday
Or
in November,
never.
right?
Yeah. Really quick before we, I'll go to you next. Sorry about that, Ryan. Just really quick, I invite comments. Everybody continue to leave your comments. We're probably not going to get to a lot of the just normal comments tonight because while we have these guys on the show, we want to lend in and lean into their time as much as possible. But if you do want to get a question out, make it a super chat. And I guarantee I'll read that while these guys are still on screen. You will get the attention you deserve. I'm not sure how much general comments we can get tonight. I already had a couple banked from my team that we will definitely get to. But other than that, I invite you guys to continue to leave your comments. I'm probably just not going to get to them unless it's a super chat, just so everybody knows. Okay, Ryan, go ahead.
Yeah, I was just going to touch on that issue with the salary cap. I mean, look, we have salary caps in pro sports, right? But they're collectively bargained.
Yep.
We have a collective bargaining agreement that governs the NBA. It talks about BRI, which is basketball-related income, and that is shared. No different than, I don't know what we want to call it here, college sports-related income, right? It's the revenue share.
Yeah.
Why is it capped at 20.5? I mean, who came up with the number? It is a restriction that was not collectively bargained. Frankly, we can get into another discussion about whether we can have a union that is governed by the NRA and the NLRB across the country for all colleges and universities. But that's a separate legal discussion.
Right.
But I look, the plaintiffs' lawyers and the lawyers for the NCAA and the conferences took an opportunity here, particularly, I think, the NCAA and the conferences. This is their way to collectively bargain, quote unquote, a salary cap. They used a class action vehicle to impose this on all student athletes and schools across the country,
rather than passing a law, which is normally how things are done.
Rather than collectively bargain, for it, rather than have a college sports union that is formed for the very purpose of protecting the interests of college athletes, and negotiating a labor deal that would be fair and equitable. And Joe's right. At the end of the day, the court has kind of turned away from all these other issues and is focused on the roster limit issue, because that is the one that, if you attended the hearing, that is, and you listen to some of the objectors, that is the one that has already caused harm across the quote unquote class that is supposed to be protected by the very settlement that she's presiding over and presumably going to approve. But there are fundamental issues with other aspects of this thing, and one of the most important is obviously this salary cap. And then we have the clearinghouse. I keep going back to this, right? The settlement, if it obtains final approval, will be binding on college athletes and schools. If the clearinghouse says, Ryan, your NIL deal as provided to you or proposed to you by whatever NIL collective somehow fails to meet fair market value and is rejected, may I commence an action?
Right.
Or because I did not opt out of the settlement many months ago, I'm bound by it.
Yeah, it's an action without an action.
Right. So where is at the end? And that's an important question. It's something that I don't know off the top of my head. As I sit here, I kind of try to work through it. But if I'm a class member and I have not opted out, and this settlement agreement, includes a mechanism by which my NIL deals are going to be vetted by some third party, what recourse do I have at the end of the day if it's rejected?
I don't know.
Right. So there's just walking through these, practically walking through these, right? Like, this is a real scenario. What if that happens in 2 years? So, look, I've read through the orders that Judge Wilkin has entered. She seems fine with the rest of the proposed settlement. She has opined already that she is prepared to approve it, grant final approval to it, but for this roster limit issue. Now, once that's resolved, and by the way, everything that's been submitted on the roster limit issue, in my opinion, by plaintiffs and by the NCAA and conference defendants, I don't think addresses fully the court's concern.
So how does it slip through then? Did they just wear it down to the point where they're just like, we need something is better than nothing?
You know, she said, here are the people you need to protect, those you have already harmed, i.e. the football player I represent from BYU,
right,
now no longer at BYU because he was told no more roster for you.
Yeah, it sucks.
You know, so many other athletes. The high school athlete, the senior, I believe her last name was Loudermilk. She, as a high school senior, stood up in a federal courtroom and presented probably the most compelling case for the injury that she has sustained as a result of being offered a roster spot in a scholarship and then losing the roster spot.
And she was one of those long, multiple-page response letter people, right?
Yes.
Okay.
And quite compelling. And kudos to her. I'm sure she's heard it 1,000 times before. But you're a high school senior and you're standing up in a crowded courtroom in federal court. You know, that's not an easy thing to do. So kudos to her. And I'll say that to the mountaintops. But at the end of the day, the judge is going to have to find that the settlement is fair and reasonable across the board to everybody. And I don't know how she's going to do that with what's been submitted. The NCAA and the defendants are almost like, they're like taking, small steps to just give her what she wants, which is grandfathering in the roster limit issue. I'm not sure why this is such a sticking point for the NCAA and for the conference defendants. In my opinion, look, I'm old enough to remember SMU, right, and the death penalty.
Yes.
In my opinion, and I've discussed this elsewhere, the roster limit issue should not be imposed or implemented until all of these kids are out of college. Right? Almost like a reverse, death penalty. So anybody who's a freshman in college, a sophomore in college, a junior, a senior
should be able to see their thing through all the way.
See it through, or even a high school senior.
Right.
Just see it through, so you don't have to look over your shoulder. At some point, somewhere along the way, you may get told there's no more roster spot here for you. Now, I don't know, and Joe, maybe you could talk about this from a university's perspective, but are roster spots, costing universities money?
This is what I haven't. It's been driving me absolutely insane. I don't know why they want the roster limits, and they obviously do, because they're putting the whole settlement at risk on this issue, and I don't understand it. And all their arguments about roster limits haven't been why they want them. It's about why they should be allowed to do them. But they still haven't explained why they want them in the first place. Now, my best guess is they're going to make, or they would make, some sort of bad faith competitive balance argument. But if you have a salary cap and the clearinghouse to kind of help any goofy circumvention and this new enforcement, none of it's going to work, but they think it is. If you have all that, how does a roster limit protect competitive balance? I mean, we saw in the NIL era with the transfer portal, kids want to go where they can play, because when you play and you start, that's how you get paid. And we had Indiana. I grew up a Hoosier fan. We had Indiana make the college football playoff this year. That's unheard of. in my lifetime. Who else?
Wait till next year.
Yeah, well, yeah. And yet Alabama sitting at home.
Yeah.
So we don't need roster limits to create competitive balance. And what are you talking about? Was it 115 for football?
105.
105. Sorry.
Yeah, but you can do scholarships all the way up to 105 instead.
Sure.
Of
well, they're not going to do that. No one's
right.
going to do that
because it cuts into the 20.5 million.
Right. And I'll put a pin in.
Okay, you can get back to that. That's fine.
The attorneys have driven me a little nuts, and I'm normally very, I defend attorneys till I'm blue in the face, because I was told I had to when I was a 1L. I was told that lawyer jokes were no longer funny to me by a state judge here in Mississippi when I was at Ole Miss for law school. But they've annoyed me a little bit. But no one's going to do all the scholarships. That 106th guy, theoretically, on Alabama's team or LSU's team, that's not going to be a difference between them winning a national championship or them getting an unfair advantage. What you're doing is you're killing walk-ons, which is it's the last cool thing left that really differentiates the NCAA from anybody else, is the walk-on that gets a scholarship or the walk-on that makes a play. Other than that, these are just pro sports that happen to wear our school's logos. And I don't understand, again, what the point of it is, because it's not going to help with competitive balance. In schools, if you're smart, I'm at Southeastern, we're an FCS regional university. Our football coach jokes all the time, and he said, I could get you 300 kids from a 3-parish area. If you could get me football gear for all of them, I'll put 300 on the team. And, we'll fill our stadium with aunts and uncles and whoever. I mean, schools would like that, as far as I know, would like to have it, because, and if they can't afford it, right, the school doesn't have, no one's telling you have to have 500 football players if you don't want them. If you can't afford them, you don't want to outfit them. But I don't understand why we're imposing a limit from schools. Anytime you hear a coach talk about this, they don't like it. They don't want it. They're having to cut kids that they recruited or that they had come on as walk-ons. I know sometimes they want to cut kids anyway, and maybe they're just using roster limits as an excuse.
Well,
fine. Yeah. But, I think by and large, they don't want to do this. They don't want to cut rosters down. And the baseball roster limit was one of the craziest ones to me. They put that at 34. I mean, getting Tommy John surgery is like a rite of passage for a college pitcher.
That's true.
It's like you didn't really pitch in college if you haven't had Tommy John, right? And so you get a couple of those guys. You can't have a practice squad. Like, what are you supposed to do if you get a couple of pop up? And so that's the one that I don't understand why they want it. I really can't wrap my mind around it. And they've not said anything, and they want it this bad that they're willing to fight it. I mean, look, the judge sent them babysitters. I said, we're not taking this settlement, and here's 3 objecting attorneys to make sure you do this stuff right.
Mm-hmm.
I don't know if I'm allowed to curse here or not, so I'll be a little careful.
Go ahead. It's your show.
It's a podcast, right?
Look, I'm just a guy sitting at my desk. So
the FCC's not listening. Don't worry about it.
No, whatever.
But so you send these babysitters, including Rutherford, who's just been a rock star, I think, throughout this whole process. And so they go there, and you come out with a deal that all 3 of them unanimously say, no, this isn't good enough. And you're just poking the bear here. And again, I don't know what the upside is. What do they think they're going to get out of this? They may torpedo this whole settlement that they've hinged their whole future on, right? And all because they just won't let more kids stay on rosters for to what end? What's the point? And I think I will say, your guy Philip Shang has given me the what for about my roster limit spiel. Sometimes I'm on his side. We're mostly on the same side. I don't go hard enough for Phil at times, but I got criticized a bit because when the proposal came out at first, I was like, well, this is not as bad as I thought it might be. And then when I kind of dug deeper into it, and people pointed out to me that the schools have full authority to give someone that designated student athlete status. That means we're cutting this kid because of the roster limits. There has to be a better system than that. I'm not saying coaches are going to act in bad faith, but if coaches always acted morally and in good faith, we wouldn't need a 465-page manual, my friend. So there has to be a challenge to it. And again, at that point, why bother? Why not just say, okay, all of you that are on rosters now that aren't exhausting eligibility right now, and all of you who have been recruited, who are in, NCAA registers all their recruits, right? you guys are designated student athletes, and so you have a roster spot. You never lose a roster spot because of cuts. And you may say at that point it's going to be 4 or 5 years down the line before you institute them. So why bother? I don't. Why bother in the first place? I really just don't. This roster limit deal is just a very, very weird hill for the NCAA to die on. And boy, they just keep on acting like they're willing to do it. And I don't get it. I can't wrap my mind around it at all. And again, if it's a cost saving issue, you don't have to travel them. And if you decide, a school decides, well, I can't afford to pay for 120 football players, no one's making that.
I'll posit a reason why I think that's the case. I think they
Love
want
to.
to reduce costs, and they want somebody else to blame for reducing costs. So Ohio State has 150 kids on their team right now, on their football team, right? They don't travel all those, but they do travel more than 100. Of all the ones that travel, there's an expense being put out. What it seems like to me is they're looking for an excuse to say, sorry, we couldn't take all those guys with us because, frankly, they didn't even suit up. We're limited to 105. So I think the schools and the NCAA is trying to reduce costs, and that's where this roster bugaboo came out of nowhere, where it wasn't even discussed 2 years ago. Now all of a sudden it's the thing that everything's tipping point on.
Yeah,
that's just my thought.
They still can reduce costs. It's like if Ohio State decides they only want 105,
but they don't want to be the bad guy.
If Michigan has 120, like, why does it matter? Those extra 15 guys are going to beat them.
What I'm saying is, it doesn't matter to you and I. They're looking for an excuse. They don't want to be the bad guy.
Yeah, but I mean, again,
I can't think of another reason to do it, Joe. I'm sorry.
I think that's fair. And again, like, I think we're always trying to think that they're a lot smarter than they are. And again, we just have to entertain the possibility that maybe everyone's just very stupid involved in all this. It's very possible.
That is possible.
They can make that own decision. And again, if you're like, well, if we cut down because of cost, Michigan's going to have 150 players. Well, those last 40 guys aren't going to be why they beat you. Like, and if they are, you're recruiting poorly. Like, what are you talking about here? And so it's just gotten, that's as good of an answer as anybody else is giving me there, Bomber. So you may not be wrong, but.
Oh, I'm probably way wrong. It just, that's something, because honestly, as I've talked about this with all the consigliere shows, all the lawyer shows, all the guests I've had on, nobody's been able to actually define why for the rosters. It's like, it came out of left field. It makes absolutely no sense to anybody who's talking about it, unless, and this is me last year when it first was announced, I thought it was a competitive balance thing. I thought they were doing it so that BYU could compete with Ohio State, and they would naturally be reining Ohio State in so that BYU doesn't have a problem with roster spots, but you get my point. I thought it was about establishing a competitive balance mean. And it's turned out to be nothing of the sort. It's not even close. It has to be something else.
Yeah, so from the ground, I've heard the same thing. It was a competitive balance issue. From coaches, at least some of the coaches in the Big East, it's a competitive balance issue for them. They don't want, X university bringing in 30, 4 and 5 star athletes to run the table in basketball. But at the same time, you're not going to have that, because 4 and 5 star athletes want to play basketball, and they're not going to want to sit in the bench and picking splinters out of their ass. And
they want to get paid.
And they want to get paid.
And they're going to go where they can get paid. If you have a cap, you don't need the roster limit.
Yeah. That's why I asked before. I mean, what is the cost component to having a roster spot? I mean, it's obviously travel and uniforms and things like that, but
again, you don't have to travel if you don't want to.
There is insurance.
Insurance
is an ongoing cost.
So for me, it's just a cost-saving measure to try to generate as much revenue as they can.
That's what I'm saying.
Look, it's not only the athletes that are losing roster spots. It's people in the athletic department.
Absolutely.
They're getting cut too.
Well, their teams are getting completely cut out, right? That's a different topic. But unfortunately, all this stuff is tied together.
Yeah.
It is the Gordian knot of Gordian knots. Somebody's going to do the 30 for 30, or somebody's going to write the great book and get a Nobel Prize out of it, for somebody who can dial back and unwrap everything between the House settlement and everything it had to do with money, to realignment, to media value escalation, and how that has broken college sports as it sits right now. The A4 just today, in the last 2 days, has come out and said it's our rules and it's our world. You either play in
Everyone
our
else is
world or you
playing
don't
in it.
play at all.
Yeah.
And I don't think that's going backwards. That's never coming back. So how do we get to a point? And that, I guess, is a next good question: is how do we get to a point where we can finally take a breather? Let's assume the judge finally signs off on this thing. I've said from day one, the minute it was announced last year, I said there's going to be lawsuits immediately.
Oh,
It might
sure.
not be in action
Appeals.
30 seconds, and it'll have 40 countersuits on it immediately. So will it ever really be put into play?
Who knows? I mean, I can promise you that there will be appeals. That much is certain, right? So then the question becomes, will the final approval of the settlement be stayed pending appeal?
Yeah.
The draft of the settlement agreement, I mean, this is wild. The draft of the fourth amended settlement agreement now says something to the effect of, the plaintiffs and defendants agree that effectively, if any appeal is filed, they won't ask for a stay, believing that not having the stay will have some impact on the circuit court reviewing the final approval, right? In other words, another instance of the train already leaving the station, right? We've seen that already with the immediate implementation of roster limits, right? The NCAA's position is, well, you can't put the toothpaste back in the tube. We already implemented roster limits. And the court's like, well, I mean, you created your own mess, so fix it. Same thing here. Everyone's agreeing in this case that we're not going to stay the final approval and the grant of final approval and then the implementation of the rest of this settlement while there's an appeal pending. I mean, even and Joe mentioned her before, but Laura Rutherford, she reserved the right to file an appeal. I mean, this thing is, I imagine within days of final approval, you're going to have a notice of appeal.
So let me ask you guys this then. Let's talk appeal. Let's talk about all the states. State of Utah, being one of the very first to implement protections, to say, we don't care what you do with House. We don't care what you do. We're going to cover our own butts. That you come to a school in the state of Utah that's public, you cannot restrict how much they make. I don't care about no Deloitte clearinghouse. Don't talk to me about any of those things. We're just going to do whatever we're going to do, and that's a state issue. And until there's a federal law put in place to countermand that, it's still going to continue to be a mess, isn't it?
So I just coincidentally, you mentioned Utah. I just revised a proposed revenue sharing agreement that was provided from a school to an athlete, a school in Utah to an athlete. And it had language in the agreement that said disagreements contingent on House. And I said, what for?
Why would you do that?
That was signed by the governor that allows you to do this anyway.
Right.
So let me just read real quick from Laura Rutherford's objection that she filed on May 13th, 2020. I very much appreciate her writing. She and I write quite similarly, so I very much appreciated it. In the very last paragraph, she says, finally, should the court approve this settlement, objector again requests that it stay the implementation of the injunction until resolution of all appeals. A stay is particularly necessary here because plaintiff's counsel has informed the public that paragraph 18, parentheses, agreeing to no stay pending appeal, is in the agreement to influence the Court of Appeals to not overturn final approval of the settlement. So you've got two parties here that are effectively agreeing to not stay implementation of this, letting it run its course while the appellate court takes however long to resolve any appeals. I mean, this thing is phenomenal. What's going on here? And I don't mean phenomenal in a good way.
No.
It's unbelievable. It really is. I mean, look, I really hope, from a kind of an outsider looking in and monitoring all of this, and there's a part of me that hopes that she just says, you know what, I'm tired of this shit. I'm denying it, because that's what I would have done. I would have done that already. And I will tell you that I've applied twice to be a federal judge in my lifetime here in New Jersey. So, having clerked there, having spent most of my practice in federal court here in New Jersey and New York, I applied twice to be a magistrate judge and got all the way down to the merit selection panel. So,
wow.
I have read this 1,000 times over, and I'm at the point now, and God bless Judge Wilkin, because she has the patience of a saint.
Yes.
Yeah.
Because this type of stuff ordinarily would piss off a federal judge.
Well, they're playing chicken with a federal judge. They're basically I don't understand it. I've never seen anything like it.
And look, in my opinion, they do so at their own peril. And their own peril is final approval denied. Counsel, let's have a scheduling conference. We're going to set trial, and that's the end of it. And then, by the way, once a trial date's set, I guarantee you that the plaintiffs and defendants will give the court exactly what she wants.
Yeah, it's a little too late. They're wasting hundreds of millions of dollars for no gain at ever. Joe, I got a question on the writing side. So you're looking at this, and you're looking for anything that you can hang your hat on. We talked about this in the green room right before the show. This thing has been mixed and mashed and mixed together and remixed. And how do you continue to tell a story around this thing that is just at this point, people are numb, right? It's like the ACC lawsuit with Florida State and Clemson.
Oh, yeah.
People were just numb. By the time that came out, they're like, thank goodness. We don't care what it was. We just want it to be over. How do you cover that from your standpoint?
Well, it's like I told you guys in the green room. I actually haven't written in a few weeks because I was busy closing out a semester, and then again, it's getting increasingly difficult to write intelligent commentary about this because it's all so stupid. And how many times have both Brian and I kind of thrown our hands up like, I don't know, because no lawyer really knows what is going on, including their own, by the way. I'm convinced. That's got to be the sweetest gig on earth, by the way. I know Mr. Killaroo there for the NCAA's defense counsel takes a lot of flack, but one, he's making the arguments they're asking him to make. And two, at the end of the day, it's like, oh, you want to do this? Hey, this is a bad idea. We're going to lose. You're going to keep on paying me billable hours. Okay, because you have to obey them. You have to obey your client at the end of the day. So he's doing exactly what he's being asked to do, and he's probably just thinking of all the billable hours he's going to get on appeal. Going forward, he's he may be disliked, but he's doing his job and he's getting paid very well for it. So, that is what it is. But it's just it's truly mind-boggling, a lot of it. And again, this, like we talked about playing chicken with a federal judge. There's just, where's the upside? Yeah. One thing we haven't talked about today, because we keep on looking about what's going to happen moving forward in college sports, because as fans, that's what we care about. Yeah. But really, the normal part of this settlement. And really, they could have stopped there, and it would have been actually I would have applauded the NCAA for a shrewd move, is the back damages. The number keeps on moving around, but like $2.5 billion-ish dollars being paid to former athletes as part of an antitrust settlement. That's normal, and it's good, because if this goes to trial, they're potentially, and they lose. Now, this trial is going to take a long time, but we're talking about limiting the NIL compensation of tens of thousands of athletes for, what's the statutory period? 5 years? 4 years?
Well, I was going to ask you guys that. Went that 5 years. Was that arbitrary, or was 5 years?
There's a statute of limitations issues. That's why the Reggie Bushes and the Mario Chalmers and all them got thrown out. They didn't pursue their case quickly enough. Okay. So basically from when the case got filed up until basically nowish, now we got people who can get NIL, but people who couldn't get NIL, even if it was just for a year. I mean, you're talking about setting whatever. Now all the bonkers money they're getting too is just going to hurt them evidentiary wise, hurt the NCAA. I mean,
right.
You set that number at zero artificially. You cap them at $0 in NIL compensation for a period of 4 years. And we're talking, again, I don't even tens of thousands, maybe even 100,000 athletes. I don't want to know what that number is.
Yeah.
But it's a big number. I've seen 4 billion bandied about. I don't know. That sounds like a fair enough guess. But then it's not 4 billion the NCAA is on the hook for. They triple it. They triple it by antitrust law.
Oh my gosh.
So that's $12 billion. That's not a real number. That's not the NCAA. That's curtains for the NCAA at this point. College sports will survive. The NCAA will not, if that happens. And so that's the disaster they're playing with. That's the cliff, the abyss they're looking into as they keep on fighting this asinine battle over roster limits. And their risk calculus is it's broken. And I promise you, Mr. Killaroo, whatever you think of him as the defense attorney, he has made that very clear to them. That whole firm, I'm sure, has told them a million times, like, this is what happens if we go to trial. And could they win an 0-0? Theoretically. But it seems quite clear this is an antitrust violation to me and everybody else who's been studying this for a long time. And so, again, that's a number that is almost incalculable, but they're going to try. And then the triplet. This is the disaster they're flirting with. And this is, so they're like, well, so what? They'll go to trial. They're not afraid of it. They really should be more scared of a trial than they are of letting a couple extra kids keep their roster spots.
Yeah. When you say it like that, it sounds so stupid. A few roster spots versus billions of dollars.
Right.
Which is why I said before, deny final approval and watch how fast they come back and give you exactly what you want.
Right, but what's the point of even doing that, right? All you're doing is costing more time. If you're going to get it anyway, why not do it now? Why?
Yeah. Well, because they're not going to give it to you.
Yeah.
Right. I mean, the NCAA has already shown its cards 3, 4, 5 times. I'm looking at these things. They don't want to give the judge what she wants. I mean, they're playing cute with the language look. As lawyers, we have to protect our clients and we have to protect their interests and we have to advocate on their behalf. As Joe mentioned, the folks at Aaron Fox, they're very good lawyers. I've worked with them before in their New York office. They're excellent lawyers. They have to do what their client is directing them to do, unless, of course, it's in violation of law. But, look, sometimes you have to take positions that you'd rather not have to take as a lawyer, but, you've got to stand up and take those positions. And I'm sure that the good folks at Aaron Fox have had conversations with their clients saying, I'm not sure this is the best argument to make, but look, you've got to make it. We have to, in every case, whether it's this multi-billion-dollar class action or $100,000 breach of contract case, we need to tell our clients the strengths and weaknesses of the arguments, the claims and positions all throughout, not from the beginning, but all throughout the case. And I'm sure they've, the NCAA's and the conference defendants have weighed those, those thoughts and the presentations from the folks at Aaron Fox, but they're taking the positions they're taking. What happens if, we don't have final approval? We go forward with a trial, and I don't think look, lightning can strike the courthouse. I still don't think the NCAA and the conferences are going to win at a trial. It's hard enough they can't win without trials, right? They lose motions, they lose cases everywhere across the country. There's not a person, I think, look, they could find a good pool of people, but I think it would be foolish for the NCAA to keep and the conference defendants to keep testing the judge, because at the end of the day, it is treble damages. At the end of the day, it could be the death knell to the NCAA as we know it. And quite frankly, I mean, look, let's be honest. do football schools really need the NCAA?
No.
Right? Let's be
No.
real here. I've had conversations. I have a very, very, very good friend of mine who played college basketball and was on the bench as on the coaching staff after graduation, after his playing days were over. And we used to comment all the time, so long before this House case was filed. Like, what if some of these schools need the NCAA for? Right? I mean, look, you already have P4s. You're already driving the bus.
Right.
It's effectively telling the rest of the college sports landscape what's going to happen, what they're going to do, and you're going to either follow suit or get left behind. What is, I don't know. What happens to the NCAA if they go to trial? At the end of the day, does it matter?
I actually, I brought that point up before. What benefit do you get if you're a big money school, and even really if you're an FCS school? Even I'm starting to wonder, what benefit do you get as membership of the NCAA at this point? You get sued all the time.
Yep.
And if you're the P4, they could break off. Or if the NCAA is like, well, you're not invited to our basketball tournament anymore, the Power Four conferences could start their own invitational tournament and get probably close to $1 billion television deal, if not higher, right away.
Yeah.
And it wouldn't take but 2 seconds,
Tennessee. Look what Tennessee just did.
Exactly. Yeah, Tennessee. Why is everything happening in Tennessee first? That's what I want to know. They keep doing everything first for some reason.
The state of Tennessee, as I understand it, is not a good friend of the NCAA. But
power to them.
You got to applaud states that are getting ahead of all this stuff and saying effectively, I guess this is a family show, so I'll use a different phrase, but go pound salt, NCAA.
Yeah.
It's a dysfunctional organization, has been for a very long time. It's just now there's nothing else to cover over the warts. Yeah. All the warts are now exposed, and you can't cover it up with more money for the power conferences or more money for the basketball tournament. All those things are pulled back now. All there is operations, and people do not like what they see.
Yeah.
Well, and let's talk about what their job is. They're supposed to promulgate rules. They do that. I don't know if they're any good, but those rules get them sued all the time.
Yes.
They're supposed to enforce rules. Well, they're outsourcing that to some new entity that we're all hearing about now. Yep. They put on championships, and for a while, that is one thing I would always kind of defend the NCAA. I was like, well, they do a pretty good job with that. And, people have different feelings about the men's basketball tournament and whatever, it's not particularly egalitarian. And now they're talking about more and look, I'm a big mid-major fan. If you can't hear it oozing out of my soul. I went to Southern Miss undergrad and grad before I was ever Ole Miss. I teach at an FCS school now. But you're talking about we need more SEC and Big 10 and Big 12 teams in the NCAA tournament. Get out of here.
No.
If you finish in the bottom half of your conference, you don't need to. But anyway, they don't even do that well anymore, especially the debacle after the women's and men's basketball tournament, the COVID bubble and all they got exposed.
Right.
So again, I'm not really. It's for all the children out there, an Office Space, reference there when he's like, well, what is it you'd say you do?
You actually do here, yeah.
Right, and Charlie Baker, by the way, I thought this guy was going to be a dynamic hire. This is a polished politician. What has he been doing?
He hadn't done anything except for go to Congress and say, please, please, please protect us from ourselves. That's all they've done.
Mark Emmert was a buffoon, but he was everywhere. Charlie Baker, did he see his shadow and go into hibernation for another month? What is he doing?
Him and Klyavkov must go to the same golf course. That's all I'm saying.
Talk about a guy who had perfect timing, though. How about Mark?
Hey, look, you're cashing checks. You know?
Mark Emmert's like, thanks, I'm out. I've done.
That's right.
Here you go. Right. Yeah, here you go, Charlie. Take over.
Good luck,
guys, I have kept you for an hour. I'm going to go for another half hour, probably 20 minutes answering questions just from the gallery. If you want to stick around.
Yeah.
Is that okay with both of you?
Yeah.
All right, let's dive in. Are
we good? We're good. All right, I'm good.
Okay, all right. I'm very proud of my my fans, the people that watch my shows. They're the smartest ones out there, and so I try to get a little bit of their stuff back in it if I can. So we're gonna dive right into comments, and I'm gonna work backwards. So first of all, thanks for everybody who's been with us for an hour. We have been talking about really anything that has to do with college sports, regulation, certainly House, NIL, and everything else. And I welcome those people that are catching us back up on X. I turn you back on just so we could have our comments and questions. So I appreciate everybody joining us tonight. All right, I'm just going to dive right in. The very first one, I got to get to this one from Timothy Green. He's my soldier out there at West Virginia, a valuable member of the Mafia family, saying, wow, I can't believe how much I've learned in the last hour. And yet, at times, I feel like we are still grasping at straws. How do you guys feel about that?
Maybe
That's
Timothy,
law
you're
school
not
for you,
wrong.
man. There you go. Yeah.
Timothy, thank you so much. It's great to see you. I appreciate you being here tonight. Let's see here. Conundrum says hit the like but thumbs up button, and that'd be great for the team. I appreciate that. Thank you.
Thank you, Conundrum.
Timothy Green says, Bomber, you are the man. Thank you. I appreciate that, Timothy. Make sure you're following these guys, by the way. Let me take this comment down. Everybody needs to follow both Ryan and Joe and follow them on Twitter and get involved. They're involved. Ask them questions, comments. Certainly, they feel passionate about the subject matter, and I would encourage you, if you have further questions, don't hesitate to ask them. That's how we met up. So I know they do have the reply on sometimes.
Yes.
Let's see here.
And the DMs.
In the DMs. There you go. Pit Snipe Husker says BYU want a Big Ten a little. Sure, Big Ten. What do you want me to say? I don't know. I support the Big Ten. I'm a fan. I'm just teasing, Pit Sniper. Stormy Cyclone, I happen to know is in Iowa State. Cyclone in the house. Love it when you have the legal guys on. Better than speculation. Look what you guys do. You
I think
made me look
speculated.
smart.
It's just informed speculation when we do it.
Yes, exactly. But thank you, Stormy. Appreciate it.
Yeah, appreciate the comment.
We'll be back to speculate a little bit more.
Stephen Pitt, Ohio Bobcat out there on the edge. I believe is that Western Ohio? Is that right? Ohio Bobcat. Is it Bobcats? I want to make sure I get that right.
Yeah, they're the Bobcats. That's
Bobcats.
Athens, Ohio, I believe. Yeah.
And that's central then, if it's Akron, right?
Athens, I think.
Okay, all right. I get geography screwed up sometimes anyway.
It's up.
He says, I really appreciate this, Bomber. Great conversation. Thank you, Stephen. Appreciate that. Daniel Gorby, thanks for doing this show. You're very welcome. Hey, man, I'll take them. Anytime people want to pat me on the back, I'll take it. BYU football, otherwise known as Shonsky, says, everybody acts like these kids have never been paid. There's more money under the table than I think over. What do you guys think about that now that you can pretty much do anything with money legally?
I think if they put this cap in play, they're just going to basically go right back to what it was before with the underground bag money.
Right.
And there's no doubt about it. And it's just that we're going to have this little pillow of 20.5 million. And like your guy here says, everything else is going to go back underground. And that's when stuff actually gets really dirty and students get really shafted, for lack of a better word. It's not a good policy way. It's not a good way to operate.
This is actually a pretty good comment. And I'm glad.
Yeah.
I don't know who this is, but I'm glad.
Shonsky is his name. That's
Sean. Thank you. Actually, I'm glad you mentioned this, Sean, because look, I guess it depends upon whether you're in agreement that athletes should share in the revenue that they produce for the universities. Because even back in the day when it was, under the table or bags of money would show up at aunts and uncles' houses or things of that nature, those bags of money were nowhere near what the athletes are being paid now for their right. Like, so, yeah, maybe you have an athlete making, a bag of cash for $5,000, but at the end of the day, that athlete's value is so much more than $5,000 to the university. So,
yep.
Look, if if you're in agreement that they should share in the revenue, then then you should be on board that they're going to get exponentially more than the bag under the table type stuff. I will say though, and I think Joe, you just touched on it with this salary cap, and even more so with this Deloitte clearinghouse stuff. I do see it going back to what it was before, right? I mean, look, let's envision a scenario where, your favorite NIL collective, which is still operating even after revenue sharing, offers an athlete, a football player, $200,000 to go to the school for NIL purposes. I shouldn't say to go to the school. And the clearinghouse says no. That is far out. That far exceeds what we believe the NIL value to be worth, and we think it's worth $50,000. Where do you think the other 150 is going to go? In a bag, somewhere, and find its way to that athlete.
Or in a meme coin.
I was going to say in a crypto coin where it's untrackable.
Right. Yeah.
Watch the NCAA flounder over themselves trying to freaking regulate crypto. No one can do that. Good luck, NCAA. Right. That'd be hilarious, actually, now I think about it.
Well, it's impossible. It's virtually impossible. You don't have to report it. Nobody would know about it. And in 10 years, you turn around, cash it in, and it's worth 10 or 100 times more than you got for it.
Yeah. I paid $599.99 for so and so's Bitcoin, a piece of a fraction of a Bitcoin.
Right.
Roll that forward 15 years.
Exactly right.
So
exactly right.
But it was a great question. I think you said his name was Steve. That's actually a very good question. I'm glad he asked that one.
Yeah, he's pretty smart. We keep Sean around anyway. James Davis checking in. He says players can have a real job. What stops them from just going to work a car lot for $2 million a year and say, what's my job? That's what my job pays me. That's what I've always said is NIL really is whatever you want to make it. And that's where the clearinghouse, I think, is ludicrous, because you could, in my opinion, you could have the guy mow your lawn once a year and say, that's it. That's what I'm paying whatever for. And who are you to tell me that's not the value of what it is to mow my lawn?
Yeah,
it's some sort of godlike figure that gets to reach down and say, this is how much it is to mow your lawn. No, my lawn's different than you guys' lawns. You're going to pay a different amount. There's no way it's transportable. So I don't know how it makes any sense at all.
So I guess so long as that the dealer principal at that auto dealership is not a booster of the university, because I guess then it would be otherwise reportable.
If they track it down, that's right.
And go through the clearinghouse. But I'm sure there are car dealerships that are not owned by boosters of universities that just happen to be friendly with universities. And yeah, sure, you could throw somebody on for $200,000-$300,000 a year with some incentives, and work your way up.
No,
you just see a lot of creativity.
Go ahead, Joe.
Didn't Rhett Bomar get in a bunch of trouble at Oklahoma for this, like in 2010? This is the Rhett Bomar thing. He had a no-show job at a car dealership, and they
is that right?
Yeah,
I didn't catch that for some reason.
That's a deep pull from me right there. But kind of similar to the crypto thing. Doug Gottlieb likes to talk about how he bartended when he was playing basketball at Oklahoma State.
Right.
Go get a job at a bar or a restaurant and have a booster come leave you a fat tip. Let's get Deloitte involved, talking about what the fair market value of a server's tip is. You're going to have the servers union coming after you at that point. It's an unworkable mess. That's the conclusion we continue to come to. But there you go.
Unworkable is the word that I've used forever. You guys, I'm glad that we all speak the same language, because it is, in my opinion, unworkable. Go Black 45, always one of the best names in social media, certainly on this show. $5 super chat, and he's also a valuable member of the Mafia family. If the P2 leave a voluntary organization to start something new, how is that an antitrust violation? No one is keeping the others from leaving as well.
I actually think this is a good point, by the way. If they wanted, this is maybe pie in the sky, it's Pollyannish of me perhaps, but if the NCAA really loves amateurism so much that they're willing to die into the abyss over it, over every little shred of amateurism they can save, then what they need to do is let the Power Four, and in all honesty, probably most of the G5, let them go.
Let them go.
Let them
I
go.
agree.
And then you govern the FCS, the low major, D1s, D2, D3, and then you're right. You do have a problem. No one can really make antitrust claims anymore, because if an athlete at an FCS school, or what it wouldn't be called that anymore, right? They're upset because the rules say they're not allowed to get paid.
That's right.
Well, the NCAA in that scenario where the Power Four exists as its own little thing, they're no longer I was going to say monopolist. It's technically monopsonist, but they're not the only purchasers, I guess, of college athlete labor. There's another gig in town, and the fact that that student athlete is not good enough to reach there, that's not the NCAA's problem. So I think the fact just having another entity that has a different set of rules actually does derail a lot of these antitrust claims. That's the problem. The NCAA is the only gig in town. It's a bunch of competitors conspiring with one another, right? And that's where you get the antitrust problems. But if you had a split in different rules for different divisions or different organizations, these antitrust claims lose a lot of their steam because, again, we don't have a monopolist in the market anymore, right? There's another show in town. You don't like our rules, you go play for the other, and that's it's a pretty astute point.
Agreed. You want to add anything to that?
No, I'm good. I'm good.
All right. Excellent. Thank you, Go Black 45, for the $5 super chat. And he also gifted a new membership, so I'm going to clap him. I don't give him many sounders around here. So
Go Black.
Go Black 45, a gifted membership. Thank you so much, Go Black 45. I don't even know who got that because I don't have my comments window open. So whoever got that, please thank Go Black. You can tell I'm not the smartest guy around here. I just do other things. I don't do the techniques. But thank you very much for the super chat and also the membership. Appreciate it. We will be doing a consigliere only private chat show coming soon. That'll be for members only. So stay tuned for that. I'll be announcing that on Twitter. But you can tell these guys really know what they're talking about, and we're very grateful they give us some of your time. I at the very least, what I can do is try to put those guys in the same room. And you guys can ask them your questions. It's not me doing the talking. It's all of your questions. So thanks a lot, Go Black. I appreciate it. Let's see here. Stephen Vitt says Athens, Ohio is in the southeast. So that's a correction. I appreciate that. Thank you very much. UCF Island says, good to see you, Bomber. Hopefully they can fix NIL because it's messy for some schools with this pending. UCF is trying to take it in-house, and we already shut our main collective, Kingdom NIL. Can I just say something to you, UCF? Why? When I hear, especially once we found out that the collectives were going to be moderated by its own sort of collective monitoring service, which is the clearinghouse, why would you shut down your collective? I've never understood that. Do you guys understand why these schools, they originally said they weren't going to bring them in-house, then they said, oh, we got to bring them in, and now all of a sudden they're trying to deregulate again? Well,
bringing a collective in-house just means that you're essentially, that's just your revenue sharing arm. So it's actually not going to be subject to the Deloitte
I'm talking
process.
About the third party. I apologize. I'm talking about the third party NIL.
Yeah, well, I mean, what I think, if you only have one collective, I know UCF's a massive school with a big fan base. I'm a big Southern Miss guy that used to be in our conference. It drove me nuts. But, if they only have the one collective, well, that collective's already got contact info, infrastructure, all that. So you bring them in-house, and if they're managing less than $20.5 million in assets or about that, well, fine. You just bring them in-house. Now, and by the way, you can actually maybe get a little bit more donated because now the donors, in theory, depending on their tax bracket, that money can actually, they can operate as a nonprofit because they're actually in the athletic department. So that money, say you're in I don't know what the top tax bracket is because I'm nowhere close to it. But say it's 30%. Well, I mean, they could in theory donate 30% more because they're not going to get taxed on that money. It's tax deductible, right? And I think I got a little fast and loose with the math there, but you guys get my point, right? So
we do, yeah.
So that's what bringing in-house means. Now, should they still have an external third-party collective? I don't know. I just feel like they're gonna get, unless you have one like you talked about with the BYU situation, where they're running a real business. They're creating content. They're creating, events or whatever, and there's legitimate deliverables there.
Yeah.
Those are going to be fine. But most of the collectives, the way they exist now, if they are externally athletic department, that's going to get you in the most trouble. It's going to be the easiest target too, for this new enforcement arm.
Go ahead.
So my alma mater, Seton Hall, is similar to what you described, Joe. So they had pre-NIL, pre-2021, they had something called Pirate Blue Athletic Fund.
Okay.
And that was the 501c3 to which alumni would donate.
That was supposed to be a tax-free one.
You got it.
Right?
So you could deduct your donation from your taxes and get a tax benefit for that.
Right.
It still operates, even though we have a separate NIL collective called Onward Setonia. And I don't know what's going to happen there, but I think in that situation where you have a university with only one NIL collective and you also have some internal 501c3, you might see the collective go away, and you may see additional contributions made to the athletic fund that is the charitable organization. So in those situations, I would tend to see maybe the collectives go in-house. Go away or be brought in-house under the charitable organization arm. In other instances, so I am privileged to represent a collective. It's a collective. It's been a booster club for decades, but now we call it a collective because that's what we're calling these things now. But the Penn State University Women's Volleyball Booster Club. Okay. And that is the organization that obviously supports the now national champion Penn State women's volleyball team.
Woo!
And that collective is not going away.
Right.
Something like that. Right. So you have maybe a sport specific collective for a quote unquote non-revenue producing sport. Maybe you'll see an outside collective stick around. And I know, Penn State has its support, external support for the football teams and things like that. Basketball.
Well, the Big Ten has their own rules too around NIL and collectives.
Yep.
That's another thing we haven't even touched on is all the regulation, and as it trickles down, there's more and more layers, right? You meant really quick to touch on BYU. Obviously, they come from being in a place where they were an island unto themselves. Nobody was helping them ever.
Right.
And so everything they've had to do has been all in the rules, within the borders. There is no coloring outside the lines, which for a long time people looked at and they said, aha, BYU's not spending money. They're not getting into the game. They're not going to be competitive. Well, lo and behold, now what we find out, it's all of a sudden NIL is quote unquote legal. It has all the protections of the IRS, so the school's not going to get sued if something happens with the money part of it. And now, BYU's got the 5th highest NIL for basketball and all of college basketball, 350 some odd schools. And in football, it's climbing quickly. And it's easy to do that when you come from a place where you're an island unto yourself. They don't owe any money to anybody. They're completely debt free. They can grow or flex as they want to control, versus the worst example of any conference I've seen since I have been covering it in this very few years has been the Pac-12. All their schools ran their athletic departments like they were a profit center, which meant they were all in major debt. ASU was to the tune of $51.7 million debt just for the athletic fund. And that's underwritten by the taxpayer. So now they can spend into the debt as much as the Congress is willing to support it because it's backed up by taxes. At the same time, their transparency laws are a lot different. So everybody has to answer to a different drummer, essentially. All right, we're going to get to a couple more comments here. Oh, Daniel's chimed in. I'm seeing this. Good to see you, Daniel. Daniel's one of our contributors around here. I appreciate thanks for your question earlier, Daniel. I hope I asked that correctly. $5 super chat tonight saying Kentucky plans on making athletics An LLC, that's right. We haven't even touched on that at all. How will that work? How do you guys envision that Kentucky LLC being a business essentially?
I'm still having trouble wrapping my mind around this one because, they don't. Kentucky is in the SEC just for turning the lights on. They get I
Right.
don't even remember what. It's they get a lot of money just as their conference revenue.
75-80 million dollars in media money.
And I think I want to shout out Matt Brown, the Extra Points writer and news. I think he wrote a newsletter about this that shed some light on it, make it seem a little less icky, I guess, than it seemed to me at first. Because this sounded like they're getting ready to get private equity in there, and I just think that's a disaster personally. But he used an example, and the person he talked to in Kentucky used an example. I believe it was one of their medical centers that kind of spun off as an LLC, and it allowed them to kind of do things a little less bureaucratically, so they get things done quicker. Right. And it's paid really big dividends. And it doesn't sound like this is going to help them escape any of their FOIA, Freedom of Information Act in Kentucky there. Like this would still be subject to it since the LLC is wholly owned by the school. So it sounded like it was more about that. Now, their statement was like, this is going to allow us to be more flexible. And I was like, well, that can be interpreted very broadly. So I'm still not entirely sure. But my first instinct when I saw that was to kind of throw up in my mouth a little bit like, no, this is gross. This is like one of the first steps of us just getting even weirder than we're already getting around here. But after I think it was one of Matt Brown's newsletters, shed a little more light on it, and I thought, well, we'll see. I'll reserve some judgment now. Maybe it's not as bad as I think.
Matt Brown, Extra Points, friend of the show, great guy, good writer, and he does a good job going into those in detail. Do you have anything on that one with the Daniel's question there, Ryan?
I don't. I think Joe summed it up, but it'd be interesting to see how, the intent behind it, to see how it's going to operate and see how it's going to work. And that's something that'll be seen. And Daniel asked the question.
Yeah, it was Daniel Gygax. Yeah, sorry.
Daniel, for you, because you asked that great question. I think what I'm going to do after we sign off, and feel free, I mentioned before the DMs are open. If you want to follow me on Twitter, X, Twitter, whatever the hell we're calling it now.
Right.
It's always Twitter, man. It'll always be Twitter.
You can put your handle right there in your name if you want to, Ryan. You can change it.
And Daniel, hit me up because I'm fairly responsive to people who message me on X. So I'd be happy to look into it. I'll take some time. Look, we got Memorial Day weekend coming up. I'm sure my fiance will be pissed off when I say this, but I'll be happy to do a little bit of research over the weekend and really look into that for you and provide some meaningful, answer. I also see you were a West Virginia fan, so I had the opportunity to represent 2 West Virginia men's basketball players over the years who went to the NBA. So that's awesome.
Here's the dichotomy. He's a West Virginia guy that lives in San Francisco Bay Area. So you mix those two things together, you couldn't be much more polar opposite in this country.
There you go.
All right, guys, this has been so much fun. First of all, I want to thank you so much for coming back on the show. We'll continue to do this, keep the conversation going. I want to encourage everybody to look these guys up on Twitter and get involved, right? Ask them questions. You don't have to wait for a show like this to pop up. If you can't reach them through DMs, just send an open tweet and just ask a question. Hey, what do you think about this? And they're very, very friendly. They don't bite, I promise. And they'll let you get around the. If you were in the same room, I'm sure they'd throw a beer back with you. But either way, I invite everybody to stay in touch and follow both of you. First, Joe, I'll give you a chance to sign off as we get out of here. Why don't you tell everybody what you do and how they can get a hold of you?
Yeah. Again, had a great time. Really appreciate you having me on here, Bomber. You can follow me there. I got my Twitter handle kind of in the under my name there. I've had it since I was in college, so there you go. And I'm not going to change it now.
Right.
And I also write for Forbes. So in the sports money section there, again, I'll try to start putting out more content. I'm sure once we actually have a decision on this settlement. I'll have some more analysis for you there. So if you want to follow me there, take a look at it. Really appreciate it. Thanks a lot for having me on, man.
Absolutely. Anytime. Ryan, how about you?
Yeah, it's great to be on. Great to be on with you, Joe, as well. And I'm a little hurt. I was quoted by Forbes, and it wasn't you. So.
I'll have to hop on. I'm not a journalist. I'm an analyst, man. I get fussed at by my editor all the time. She tells me to get comments. I'm like, I don't know what I'm doing here.
Nobody's quoted me, Ryan, if that means anything.
You've got your own show.
Yeah, well, I make my own news, I guess. So, anyway, keep going. Go ahead.
Yeah, so thanks a lot for having me again, obviously, and it's really a pleasure to be able to just sit around and shoot the stuff about this the college landscape and what's going on with people who enjoy it and with your following who enjoys it as well. I mean, this is a critical moment that we're in right now for all of college athletics. Whether you're a football fan or you're a track and field fan or whatever it might be. I mean, this is going to impact everything. And it's I don't want to sound corny, but it really is from my perspective, kind of cool to watch and to be I guess tangentially involved in some of the stuff, having represented a number of athletes. But look, all eyes will be on Judge Wilkin. As you see, the parties got their submissions in even before the deadline, which in the legal practice is largely unheard of. But look, I guess everyone's pushing for a quick decision. So, I think Joe, I can speak for Joe when I say this, we'd be happy to come back after, Judge Wilkin renders her decision and have another chat.
Absolutely. We will absolutely do that. I want to also bump tomorrow night's show. I'm going to have Bob Thompson on. I don't know if you know who he is, but the retired president of Fox Sports and the creator of the Big Ten Network. He's coming on my show tomorrow night. It's just going to be he and I. And again, talk about shoot the bull. That's what we do, is we talk about the business of college sports, and maybe we'll talk a little ACC, which he helped negotiate that deal, by the way. Bob Thompson did. And then we're going to talk Pac-12 Mountain West Conference in fighting. Where does the best of the rest G6 conference go? So I want to thank everybody else for joining us tonight. All the great comments and questions. You guys are great. Best in the business. I want to thank Ryan and thank Joe. You guys have a great night, and we will talk soon, okay?
Thanks again.
Okay? We'll see you later. You guys have a great night. Bye-bye.